I wish to thank Judge Rangel for his very good presentation. We have a few minutes to go before the coffee break, and we are now going to have our discussion session. I wish to invite any comments or questions you might have from the floor to either Mr. Lodge or to Judge Rangel. Thank you.
Ira Machado, CPRM. Eu vou me dirigir ao Mr. Michael Lodge na sua exposição a respeito dos regulamentos, de tudo aquilo que está sendo levado em consideração pela ISA, especificamente com relação à minuta do Mining Code, Código de Mineração. Eu gostaria de levantar um ponto a título de sugestão para que fosse discutido dentro do âmbito da ISA, que é o seguinte: com a experiência que nós temos na mineração convencional em áreas terrestres, as nações mais modernas começaram a aplicar o Instituto da Financial Assurance, ou seja, em português seria traduzido por uma caução, no caso da extração de bens minerais. Tanto quanto eu entendi, a minuta que foi apresentada pelo Mr. Lodge diz respeito à fase anterior, que é a fase de exploration ou pesquisa mineral, como nós traduzimos em português. Entretanto, considerando a duração dessa fase de exploration, que foi estabelecida em 15 anos, a tecnologia avançada que terá que ser utilizada por empresas, seja empresas estatais ou empresas privadas, os investimentos que serão realizados em torno desses projetos, então eu venho sugerir que seja incluída uma provisão de fundos através do contrato a ser celebrado entre a empresa e a ISA, com a finalidade de proteger o meio ambiente, considerando que ao longo de 15 anos a empresa responsável pode vir a falir. E havendo uma falência, isso seria altamente desastroso para o ambiente da área, né? E que, a meu ver, não havendo esse tipo de provisão, o encargo, o ônus, cairia sobre os ombros do Estado correspondente. Então, isso fica apenas como uma sugestão ao compararmos o que acontece com a mineração convencional em áreas terrestres. Muito obrigado.
Okay, yes, thank you very much for the suggestion. The point you raise is a very interesting and important point. Of course, in my presentation, because of the time constraints and the size of the area to be covered, I could only be very brief. But in fact, the detailed regulations that we have at present go some way towards dealing with this issue. First of all, I mentioned in my presentation that an applicant must show that he has the financial capability to carry out exploration. And that capability includes all aspects of the regulations. The Legal and Technical Commission must assess that against the responsibilities that the contractor has. And it's very clear in the regulations, if you look at them in detail, that contractors would carry liability for any damage to the marine environment, and that their financial capability must reflect that. because they can be held liable. They can also be required by the council to repair any damage that is caused to the marine environment. There is also a provision in the regulations that actually requires the council in due course to consider this very issue of financial guarantees against potential future environmental damage even after the end of a contract. So the sentiments you have expressed, I think, are very relevant and are reflected in some way in the regulations. And of course this is an issue that I think that in future years it is likely that the council will take up those issues and look at them very seriously. Thank you.
Thank you very much. I have a question for Michael Lodge. You made a very clear explanation about the nodules regulation, but we know that for sulfides and crostals, there are some very important difference concerning fees, concerning participation of the seabed authority, and also size of area. Could you give us a little explanation about this difference? Thank you.
Thank you, Kaiser. Yes, I think that what I can say about sulfides and crusts is, of course, that regulations to cover exploration for sulfides and crusts are presently under development by the council. They've been discussed for a number of years, and the regulations are currently in a fairly advanced state of development. For the most part, everything that I said about nodules applies also to sulfides and crusts. The process for application will be almost the same. The content of the contract will be almost the same. The legal background is almost identical. The main areas where there will be a difference, and that is currently the area of considerable debate in the council, is the size of the area to be allocated for exploration and the level of the fee to be paid. And the reason why that's different is that the nature of the resources are very, very different. Nodules, as you know, are two-dimensional. They are spread out on the seafloor, so you know roughly where they are. And as you saw, a contractor is allowed to claim up to 150,000 square kilometers. Now, in the case of crusts and sulfides, that would be completely inappropriate because they're totally different resources. They are not two-dimensional, they're three-dimensional, and they occur in very, very different geological scenarios. So the area needs to be different. And there is currently, for perhaps the last 2 years, there's been a very, very intense debate, primarily a technical debate between experts as to the sizes of the areas that are appropriate for exploration areas. The website of the authority has got many expert and technical papers and reports of the discussions for those of you who want to look at it further. But it's a very complex issue, but those are the primary differences that we are discussing. And hopefully we may come to some conclusion of that discussion during 2009.
Tá, só comentando que há uma solicitação de se fazer a pergunta também em inglês para que possa ser retransmitida pela internet também a tradução. Pessoas de fora possam ouvir. Dessa maneira eu vou me permitir fazer a pergunta em inglês. And the question is direct to Mr. Lodge and the Professor Manotas Rangel. And it's relating to the convention says that to ask it for exploration of a reserved area, the company or the enterprise need to be sponsored and effectively controlled by a developing state. So I would ask Mr. Lodge to elaborate on the case that we have, the discussion that we have had regarding a company that is sponsored by a developing state, but there was some doubt about if it was controlled by that developing state. And the question to Professor Marta Rangel would be regarding the interpretation of this. What would be a company to be sponsored by a developing state, and what means effectively controlled by a developing state? Thank you.
Maybe I'll try to give an answer first, and then a more eminent jurist can give the correct answer. But, well, the words effective control are not specifically defined in the convention. So you can look at it in several ways. You can look at it in the context of economic control, and perhaps if you think in terms of company law, that might be the way that you would think of it. Or you can look at it in terms of regulatory control. If you think of the case of civil aviation, for example, that is how the International Civil Aviation Organization might look at effective control in terms of granting air rights. But you can also look at it in terms of the convention and the whole requirement of state sponsorship. And that's set out in Article 139 of the convention, which defines the responsibility of a sponsoring state. And effectively, it says that the sponsoring state has a responsibility to ensure within its legal system that a contractor that is sponsored by it shall carry out activities in the area in conformity with the terms of its contract and its obligations under the convention. So without any better definition that is not provided for us by the convention, it seems to me that that's the immediate place to look. If a sponsoring state is prepared to give an undertaking and an assurance that it has that capacity to ensure that its contractor carries out the contract, follows the terms of the contract, and acts in accordance with the convention, then it seems to me that that amounts to effective control for the purposes of the convention. And certainly that might be the case until we hear otherwise. And the only place that we might hear otherwise is from a competent court or tribunal. So let me pass over to the competent court or tribunal to provide a definitive ruling.
Yes, of course. Thank you very much. Well, I think the answer is not possible to give by myself by the statute of the International Tribunal for the Law of the Sea itself. Look, for instance, at Article 21 on jurisdiction of the tribunal. Article 21 of this statute says the jurisdiction of the tribunal comprises all disputes and all applications submitted to it in accordance with this convention, and all matters specifically provided for in any other agreement which confers jurisdiction of the tribunal. I think the answer should be given by the tribunal, but in accordance with Article 21. Well, I mentioned before when I explained how to promote the development of the tribunal, I mentioned this point, taking into account precisely Article 21 of this statute. I think in this case, it will be convenient to take an agreement between or among, for instance, not our country and other countries. And on the basis of this agreement, go to the tribunal and ask for a decision according to this agreement. What is important in the international tribunal system framework is to allow any state to get in agreement with other states, and on the basis of this agreement go before the tribunal. And in this case, the tribunal would have the necessary jurisdiction to answer the question or to settle the dispute. This, I think, it is the way for developing the international law system regarding either the seabed authority and also the tribunal on the law of the sea. So, go to an agreement, in our case, for instance, Brazil and other countries in the same region, trying to get in conversation, in negotiations, in order to obtain an agreement, and on the basis of the agreement go to the tribunal or go to the seabed chamber of the tribunal. Thank you very much.